Appreciate everybody's patience. The good news is Nashville continues to grow. The bad news is the traffic sometimes gets unbearable. So welcome to, I'll go ahead and call this Wednesday, September 26th meeting of the Tennessee Athletic Commission to order. We'll go ahead and open it up for roll call.
Yes, sir. Thank you, Chairman. Mr. Hanna?
Here.
Chad Chilcutt?
Here.
Joe Smith?
Here.
Tracy Miller-Davis? And Don Wynn. Let the record show that Wynn and Miller-Davis are absent, and we do have quorum. Let me just jump right in to get things moving. Notice of September 26, 2017 meeting of the Athletic Commission was posted to the website on September 19th, 2017. We do have to, I think we're going to move the formal hearing first. So to do that, we just need to approve that amendment to the agenda. And also, so if someone can make an amendment or a motion to move the formal hearing first, but also to allow freedom in the agenda to accommodate our guests today, that would be very helpful. We'd appreciate that.
I'll make that motion.
Thanks, sir.
I second it.
All in favor?
Aye.
Aye. Aye.
Thank you. We'll just jump right into the formal hearing.
Mr. Kopchik. All right, members of the board, my name is Steve Darnell. I'm an administrative law judge assigned by the Tennessee Department of State Administrative Procedures Division, and I've been designated to sit with your board today, the Tennessee Athletic Commission, to hear the case concerning Michael Lunsford, docket number 12.43-144053A. As the administrative law judge, I'll govern the admission of evidence and the proceedings this afternoon under the authority granted to me by the Administrative Procedures Act. I will not participate in the board's findings of fact or conclusions of law or its ultimate decision on this matter. Members of the board, you've already noted, Mr. Hanna, you're our chair here, but this does constitute a quorum of this board, is that correct?
Yes, sir.
All right, does any member of the board have any knowledge of this case, Mr. Michael Lunsford's matter? Everyone shaking their head no, so we can move on. The law requires you to disclose that on the record if you did have any outside knowledge of it. Members of the board, let me caution you that before we begin to hear the argument for counsel and proof, you're to make your decision on the disposition of this case today based only on what you hear presented to you by witnesses that are under oath, and perhaps exhibits may be introduced to you for examination. The state is represented by Attorney Sarah Page. Ms. Page, is the state ready to proceed?
Yes, Your Honor.
All right, Mr. Lunsford's present, not represented by counsel. Mr. Lunsford, are you ready to proceed?
Yes, sir.
All right. Ms. Page has previously placed a copy of the notice of charges on each of the board members' desk. I understand Mr. Smith has just arrived, so you're still looking at that. So let's just take a short pause and let him and the other members of the board review that. That'll be very helpful to you to understand why we've been called here today. Once we've completed that, we'll hear opening arguments from Ms. Page. All right, members of the board, we ready to proceed?
Yes, sir.
All right. Opening statements, Ms. Page?
Yes, Your Honor. Good afternoon, members of the Commission. My name is Sarah Page, and I'm a disciplinary counsel with the Department of Commerce and Insurance. We'll be proceeding before this board probably more frequently as Matt Reddish has exited the department and moved on to greener pastures and private practice. Today I am here before you in the matter of Michael Lunsford. This case is brought before you based on Mr. Lunsford's misrepresentations of the status of his disciplinary history in the state of Kentucky in his application, as well as the state of his health. On July 9th of 2016, Mr. Lunsford was indefinitely suspended in the state of Kentucky due to 6 consecutive. Today you will hear evidence that despite that indefinite suspension, Mr. Lunsford applied with this commission for a pro boxer combatant license on September 8th, 2016. In that initial application today, you will see evidence that Mr. Lunsford disclosed a 30-day suspension, however, did not disclose the indefinite suspension. A week later, in his pre-fight combat documents, instead of disclosing any disciplinary history, you'll see that Mr. Lunsford, in fact, checked no, that he had no previous disciplinary history related to his profession as a boxer. In addition, when you look at these documents today, the application that Mr. Lunsford sent, you will also see that there's a contradiction between his ability, or rather his medical history, related to his ability to breathe. Mr. Lunsford, in the documents from his doctor, you will see today, has a history of asthma, moderate asthma that has to be controlled with medication. But rather in his application, he checked that there were no breathing problems notable that would interfere with his ability to perform. Under the laws of this commission, 68, 115, 209, A8, and 11, this commission prohibits boxers from deceiving this commission through its application process, whether that's through an intentional omission or misstatement or misinformation. Additionally, it is considered a violation of the laws and rules of this commission to receive a license that is obtained by fraud. After hearing from Glenn Kobchak, sorry if I mispronounced that, Glenn, as well as looking at the evidence today, I think you will see that Mr. Lunsford, if was honest in his initial application, would never have received a boxing license from this commission. For those reasons, we would ask that this commission correct that error and revoke Mr. Lunsford's license number 2536 in order to remedy this error. Additionally, pursuant to the rules, we ask that the costs of the investigation and this proceeding be assessed against Mr. Lunsford for these misstatements. Thank you.
So, Mr. Lunsford, typically, if you had an attorney, you'd make an argument at this point, but no, sit back down, Mr. Lunsford. Yes, sir. The board, no, that's okay. The board needs to hear what you have to say under oath. So we're going to hear the witnesses for the state, and after the parties have testified, I'll remove you from your oath and allow you to make any argument you want to make at that time. Yes, so, members of the board, at this point, I want you just to assume that Mr. Lunsford disagrees with everything Ms. Page just said, that he doesn't buy into that. So we'll proceed with the evidence, and Mr. Lunsford, you'll have plenty of time to make your argument. Ms. Page, what's your first offer of proof?
Yes, Your Honor, if we could call Glenn Kobchak to the stand.
Certainly. Ms. Clerk, place you under oath. Do you solemnly swear or affirm to tell the truth and nothing but the truth, so help you God? All right, have a seat there, Mr. Kopchak, and state your full name for the record.
Glenn Kopchak.
Kopchak, okay,
Yes,
thank you.
Good afternoon, Glenn. How are you? You just introduced yourself for the record, but can you tell us your position with the state?
I provide administrative oversight over 15 boards, and one which includes 10. Other responsibility is custodian of the record, which it also includes licensing, regulation, and referring complaints to the board as well.
How long have you held that position?
Since January, the beginning of January, January 4th.
What is your actual title with the state?
It's Assistant Director, Administrative Director.
Are you familiar with the respondent's matter in this case, Mr. Lunsford? Is Mr. Lunsford licensed with the Tennessee Athletic Commission?
Yes.
Can you explain to us a little bit about what that process looks like to become licensed as a combatant with your commission?
Well, they fill out an application, like all of our other boards, attesting to certain facts within that application. That attestation at the end is basically them confirming under oath that these things are true. And the things that they're attesting to are just general suitability, eligibility for that license, as would be the case with Mr. Lunsford as well.
Does that include disciplinary history from other states?
It often does, yes.
And does it also ask for any medical information?
It does, and then with the Tennessee Athletic Commission, it does ask for medical information and past disciplinary history as well.
Do you recall when Mr. Lunsford became licensed with the commission this time?
I haven't committed everything to memory, so I have to look right quick, but. His first license date was April 26, 2016.
I'd like to talk to you about the complaint at issue today. Can you tell us in general how the complaint came to be opened?
It was an administrative complaint. Once the pre-fight evaluation was compared to the application itself, and I think it was, I don't have the dates in front of me, but it was within 2 weeks, somewhere in that range, then there was some inconsistencies as to reported asthma and disciplinary history.
When you say administratively opened, do you mean that it was opened internally?
That's correct.
Is there someone on staff that reviews application, or can you tell us how that might have come to be?
It can happen many different ways. We have some complaints are opened by, when the public was to call, if they call a complaint line. We also, of course, will open up administrative complaints, which in that case, if it's referred to us through staff attorney, whoever is touching those documents can refer to administration to open up that complaint. Licensing as well.
And Vanessa Huntsman, our paralegal, is passing out a document, and when you receive, well, they're passing out 3 documents. So when you receive that, if you can tell us what those are. And if you'll tell us kind of one at a time what these documents are to you, if you know.
Sure. First of all, if I can start with the application itself. The application would be the larger document, the one that's stapled, or there's 2 that's stapled, but the larger document of the 2. It'll say Athletic Commission Boxer on the front of it. That would be the actual application.
At the application for Mr. Lunsford?
It is.
What about the next document?
The next document would be we'll look at the next staple document. It's called the Combatant's Pre-Fight Physical Examination Report. And this was 9/17/2016, and the application itself was 9/8/2016. So about what I thought, somewhere in the range of 8, 9, 10 days.
And what's that third document that you were passed?
The third document is a fighter report. It's basically all the results are posted by commissions typically, and then certain sites will post those results, adopt those results, and then post on their website. Also on this, typically they'll list suspensions as well.
Is this a document that your staff usually looks for when they're reviewing applications?
Yes, ma'am.
Is it something that you would rely on in ensuring applications are accurate?
We would, yes, ma'am.
Your Honor, we would enter these Exhibit 1, 2, and 3.
No objection. I would just would like to clarify which one is 1, which one is 2, and which one is 3.
The application, which is the larger packet, is Exhibit 1. The second one, exhibit will be the combatant pre-fight physical examination. And the third will be the fighter report dated September 21st, 2016.
And what I want to do is kind of look at these documents together. 'Cause I think you talked a little bit about having some some misstatements. So if we could look at Exhibit 1, that application first. On page 3, there's a question about disciplinary history. Can you tell us kind of how that question reads? Will you read that to us? Oh, sure, yes, it's page 3. It's going to be the second question, rather.
It'll be listed at the very top. It says, have you been suspended by any state athletic commission or other sanctioning authority? And in this case, he checked yes. And then if yes, give details and attach any records. The records are, as he stated, it says TKO lost 30-day mandatory suspension.
And then on this Exhibit 2, the pre-fight physical, I want to draw your attention to question number 3. Can you tell us what that says and what the response?
Question number 3. Are you on suspension from any other boxing commission? He answered no.
Was there anything about this that stuck out to you and your staff when you were reviewing this application?
Well, two things. I didn't refer it, but I imagine the reason it would be referred typically by process would have been the inconsistencies. And once you compare the inconsistencies, one would be the health, and then the other would be the suspensions. We have a TKO listed by the respondent himself on the application, and we have on the fight facts, we have an indefinite suspension listed there as well from Kentucky Commission, but then on the pre-fight physical on question number 3, as stated, he claimed no as far as suspension from any other boxing commission.
On the fighter facts you mentioned, is that the discipline that's listed at the very bottom of Exhibit 3?
That's correct.
When you look at this, can you tell why that suspension was imposed by Kentucky?
There's automatic suspensions. If it's a KO, it's 60 days typically with most jurisdictions, or if it's a TKO, it's 30 days. And Mr. Lunsford did mention the 30 days on the application. However, in this case, it's indefinite suspension not for necessarily for TKO or one incident of TKO or KO, but for 6 consecutive losses. A lot of jurisdictions, if you have so many consecutive losses, they suspend you indefinitely until you can come before the board or their commission to review your general suitability to continue fighting. So it's not, you don't automatically come off that suspension 30, 60 days once cleared by a doctor. You have to come before the board. That's usually how that works.
Do you know, just from your position, some of the reasoning for that, why that would be required?
It's keeping with our mandate, protect the public and general welfare of the public. And our licensees are part of the public. And so we want to look after their health and make sure that in that partnership with them in that regard that we're doing our due diligence. And that's typical. I can't speak for Kentucky, but since there is some sort of trending in that direction, I would imagine that would be the same reason.
You mentioned the fighter facts also having the record of the boxer. Can you tell what the record was when this report was run for Mr. Lunsford?
I have 0 wins, 9 losses, 1 draw.
Okay, turn back to the application and look at, the pre-fight fact sheet, that number 2 exhibit. I wanted to draw your attention to question 6, if you could tell us a little bit about that.
It reads, do you suffer from shortness of breath, pounding, palpitation of the heart, any pain or pressure is how it should read, in the chest, or have you ever been told that you had any disease of the heart? And if so, explain. He answered no in that regard.
Now if we can look at the application into the medical documents, page 10 of the application. Is there any information here that would have drawn the inconsistency or something of note to your staff?
Any anomalies into health or general suitability for a combatant sport. Obviously, the standard, there's a little bit more latitude when it comes to a combatant sport as it may be compared to some of our other licensees. In this regard, his general health, asthma, we would look at that a little bit more carefully. And does mention that he has asthma, and explain, and then his statement was moderate, persistent asthma without complication, managed with, I'm not sure what the writing is on beyond that, but it's managed with, I guess, the treatment for asthma.
This page we're looking at, who typically fills this out?
This would be the applicant who would attest at the end that these, or affirm that these things would be true.
On the second page, there, or sorry, rather the next page, page 11, under the examining physician, is there anything of note there?
Yeah, you would have, yeah. The examining physician at this point puts just the comments itself.
Yes.
Yeah, based on your personal observation, review of the test results and considering commission rules, is it your medical opinion that this applicant is physically fit to be licensed to compete in a combative sports? He puts, this physician checked yes, but then he explains the conditions of that. It says unless shortness of breath, wheezing occurs, or active outbreak as well.
Not read
Yeah.
that part, sorry, Glenn. I've got that redacted on my copy. Apologies. And can you tell us when you get a complaint, does it get sent out to the respondent to submit a response?
Just what the turnaround is?
Or is that how it works? Do they get a chance to respond?
They do. They're notified typically in a letter explaining what it is that they're being what they're being charged with.
In this case, did Mr. Lunsford respond to the complaint? If I handed you a copy, would you want to look at it and see if it looks
That would be
familiar?
great, yeah.
Perfect. That's no problem at all.
We get responses in many different routes. So when you said response, I'm not sure if you meant like a formal response. We have some that will send an email, some will call us or show up. But in this regard, it does appear that he sent an email.
Is this a document that you would typically keep as part of the complaint process?
Yes, ma'am.
Do you recognize who he would have emailed in staff?
Yes, it was Aman Yusuf. He's no longer, or she's no longer with us right now, but it would typically be still kept in the record, and that chain wouldn't be broken.
Your Honor, we'd enter this as Exhibit 4.
Any objection, Mr. Lunsford?
Oh, no, sir, I did make this correspondence, and I feel as if I argued everything appropriately.
I'll let you explain that in a moment when you're under oath, and so without objection, I'll admit it and mark it as Exhibit 4.
Questions, Your Honor?
Mr. Lunsford, do you have any questions you want to ask Mr. Kopchak?
Yes, sir.
All right. Ask him your first question there.
Hello there, my name is Michael Lunsford. It's nice to meet you guys today. Sorry it's under such search. Oh, Mr. Glenn Kopchak. Okay, I just have it's with any questions regarding the health issues as far as asthma here. Okay. Okay, I'd like to go to the State Department of Commerce and Insurance Tennessee Athletic Commission pre-fight examination report. I would like to go to Question 6 here says, do you suffer from shortness of breath, pounding or palpitation of the heart, or pain or pressure in the chest, and have ever been told you had any disease of the heart? Does that question ask me if I had asthma?
No, sir, it does not.
Shortness of breath.
Let's say, do you suffer from shortness of breath? Yes.
Didn't suffer from shortness of breath. Did I mention that I suffer from a shortness of breath? In any form that you have, any application that you have, anything I filled out, did I mention that I suffer from shortness of breath?
Just that you had asthma.
Forms in which I turned in from my doctor, did it mention that I suffered from any of these issues?
No, Mr. Copsick?
No, I guess I should be more clear. I apologize. No, I don't see anything listed about shortness of, or I don't see anything listed that says shortness of breath from you. No, I don't. Or from the doctor. It says that I think he just warned on condition that if that was to occur, then you're fit. Let me just read what he says. I don't want to be calling from memory. Yeah. Examining physician stated that you would be physically fit for combative sports unless shortness of breath, wheezing, and wheezing occurs.
I passed a pre-flight physical.
Pre-flight physical is of course a compilation of your answers as well, but you were cleared on this, yes.
Did the nurse report any shortness of breath or wheezing?
There's nothing listed by the physician, examining physician.
All right, any other questions, Ms. Lunsford?
I believe that'll be enough for that time being.
All right. So, Ms. Page, what's your next offer of proof?
Your Honor, if I might, I would like to enter the affidavit of Tom Neal. This affidavit was noticed, it was objected to, however, continuance was granted, and the opportunity for deposition occurred, and no opportunity was taken by the respondent. So we would ask that this be entered pursuant to Section 313.
Any objection, Mr. Lunsford?
I didn't fully understand what was happening.
He's got an affidavit she wants to put into evidence. Do you have any objection to it being admitted?
I would ask this be suppressed due to the fact that it's hearsay, and I was formally notified of any indefinite suspension.
Well, the affidavit, as I recall, this is that there was an objection to the affidavit, but then there was never a deposition taken.
That's right. Pursuant to Section 313 of the UAPA, subsection 2, as long as an opportunity has been granted, it contemplates that an opportunity be granted upon the objection. This hearing was previously set in June, and that was the same time the objection was made, and we are now at the end of September, and no deposition was requested. Additionally, I have a witness that met with him where that was contemplated but never conducted.
So under the statute, Mr. Lunsford, it's admissible. You had an opportunity to cross-examine the affiant, and that didn't occur. So I'll admit it and mark that as exhibit number 5. Over Mr. Lunsford's objection.
If I may, Your Honor, give the commission a second to read that.
Certainly, you can publish that to the commission.
State rests.
Mr. Lunsford, are you ready to address the board at this time, testify? Mr. Kopchik, let me ask you to change seats with Mr. Lunsford so he can take that as our witness stand. Situated there, I'll place you under oath.
Yes, sir.
All right, if you'll raise your right hand, Mr. Lunsford. Do you solemnly swear or affirm to tell the truth and nothing but the truth, so help you God?
I do.
All right, so tell the board why you think that the state's wrong about this, or the commission, I apologize.
I would like to state that I was never notified of an indefinite suspension. I had no knowledge and was never formally notified of any indefinite suspension prior to filing this application, and this came as a surprise to me. I forget what this form's called. You have to excuse me. I've never been to law school. But anyhow, as far as I can see it, this application, this affidavit is hearsay, and I did have notification of which was the letter that came from the state of Kentucky there, and stated that I was on a mandatory 30-day suspension after a TKO loss, which did not result in any serious injuries whatsoever. None of these losses resulted in any serious injuries or required any sort of hospitalization or medical treatment outside of a Tylenol. I feel as if I've been picked on by Kentucky. Every one of these TKO losses, I showed up to a fight by myself and I stood alone. I was teamed up on. It was a teamwork activity. These losses were unjust. I came to the commission and argued that I would like to file a complaint. I was turned a blind eye and a deaf ear. I would also like to state that I've passed every physical examination required by the great state of Tennessee, as well as lost my mind there, sleep deprived. This form here, at that point in time, I feel as if I answered honestly. That's all I have to say for now.
Afternoon, Mr. Lunsford. I appreciate you coming here. You're working third shifts right now, aren't you?
Yes.
Well, I appreciate you coming when you're normally sleeping. I tell you
Oh,
what.
yeah, it's rush hour traffic on the way as
Absolutely.
well.
You're not used to that working at night. Do you know that you have an indefinite suspension in Kentucky?
I am aware of that today, yes.
You knew that because you had petitioned their board, right?
No, I didn't petition their board as far as any indefinite suspension prior to filing this application. After learning of it, I didn't go there in person, but I have called, and but there was no petition filed, and there was no normal formal notification of any indefinite suspension prior to me filing any of these applications here.
So you're still indefinitely suspended in Kentucky right now?
As far as I know, yes.
You need to appear in front of their medical commission first, right, to get that lifted?
sure how that works, honestly.
But prior to that, you were suspended 15 days in Kentucky, weren't you? In 2006?
Days. No, I only fought in Kentucky once.
Now, if it was prior to 2009, would it be on that report?
Fought in Kentucky as an amateur,
An amateur?
and I didn't lose. I won.
Todd Deal, the inspector from Kentucky's lying when he says you have a 2006 15-day suspension.
Yes, he is lying. He is lying. Yeah.
For a record, with 9 losses and 1 draw, how many times did you make it out of the second round in those?
Time so far.
You made it out of the second round?
Yes.
You said when you were testifying that the reason you've lost is that folks are ganging up on you.
For the most part, despite the Bissett fight here, I walked out on that fight because go on. So I didn't dive, and but I didn't feel as if I was going to get a fair shake. Should I put the work in to go 4 rounds?
Do you remember a meeting with Matthew Reddish with the department?
Yes, I do. Mr. Reddish was very kind. I spoke with him very clearly.
Do you remember telling him that you were getting paid by promoters to take dives?
No, I never told him I was getting paid to take a dive.
On your, you have a history of asthma, at least prior to, you admit that you have a history of asthma.
Yes, I have suffered from bronchial asthma, but it's allergy-induced, and it's not exercise-induced, it's allergy.
Okay, so you have a albuterol inhaler for when it's something like now ragweed season.
Yes, ragweed. Right now, it's the fall flowers are starting to bloom, so yeah, they'll.
I know a lot of us are feeling that right now, for sure. And now, but if you were fighting right now, you would want your judge to know that you had asthma, didn't you? Wouldn't you?
Well, I filed that on my my application for my licenses that I had asthma. I didn't feel as if I was hiding anything from anybody.
When you have asthma attacks, do you tend to have shortness of breath when it's at least allergy season?
No, I still breathe deep and long. The problem with it is the restriction of the airway. It's not a shallowness of breath, it's a restriction of the airway, which means it's harder to draw it in. It feels as if it's something choking off your air.
Wheezing.
Yes, and wheezing whenever I have a lot of sinus drainage, it causes wheezing.
You know that the inspectors and judges use these documents to ensure that you're safe in the ring, right?
Yes, I agree.
So if you were having an asthma attack in the ring, you would want your judge and inspector to know that you had asthma, wouldn't you?
Between rounds, they did know. He asked me if I had my inhaler prior to the fight beginning.
So you should put that in every document you fill out to the commission, right?
Yes.
On those documents, there's a place where you attest that everything in there's true, right?
Let's take a look at things here.
Of Exhibit 1, applicant affidavit. I have fully read and understood the application and the information given herein is true, correct, and complete. To the best of my knowledge, I agree to provide the commission complete copies of any and all document upon which any yes answer is based. I will furnish all additional information or documentation as may deem necessary. Is that right? You swore to that?
3. Yes, that is my signature.
So when you realized that you had some material misstatements, you should have given the additional information to the commission, is that right?
Some information was given. The referee asked me if I had my asthma inhaler prior to the fight, in which I said, yes, my cornerman has it.
So you submitted your indefinite suspension to the commission?
No, I had no prior knowledge to any indefinite suspension.
Because Todd Neal, the inspector from Kentucky, is lying in a sworn affidavit to the state of Tennessee, to which he has no loyalty or needs to lie.
Not on my burden to prove my innocence. It's on the state to prove my guilt.
Members of the board, you have an opportunity now to ask witness questions relevant to the allegations in the notice. I'd caution the board, if you have questions, to not make this a time to express your opinion of the case, but to reserve that for the time for deliberation that we'll get to later. That says, any member of the commission have questions for Mr. Lunsford?
I don't.
None? No takers? That's good. Mr. Lunsford, anything else you want to tell the commission before we ask you to step down?
With all due respect, I
Mr.
do
Lunsford, I'm
respect
going to give you an
that.
opportunity to argue in a moment, too, so it's not time for your argument, but just to testify to what facts you think the commission needs to know.
I passed all the medical requirements mandated by the great state of Tennessee. Prior to the fight, I passed all physical examinations prior to the fight. I was cleared by a nurse, and I've been cleared by a doctor many times. I'm an honest man, and I have no need to lie to anyone. I had no prior knowledge to Kentucky's indefinite suspension before this mess. I'm not looking for any trouble. I'm a working man. I thought I could make something out of myself with this business, but it's a hard business to be in.
You can take your seat back. Rebuttal, Ms. Page?
No, Your Honor, we can proceed to closing statements.
Closing comments, Ms. Page?
Yes, Your Honor. Members of the commission, you've seen the evidence today that Mr. Lunsford was put on notice of his indefinite suspension in Kentucky by Mr. Todd Neal. Todd Neal is a well-respected inspector for the Kentucky board, and prior to the boxing ring even starting, you'll see in that affidavit that Mr. Neal notified Mr. Lunsford that this was his last chance. The state of Kentucky did what it believed it needed to do to protect its licensees and to ensure the competitive nature of boxing in that state when Mr. Lunsford yet again fell to a TKO loss before proceeding past the second round. At that time, Mr. Neal gave notice to the licensed second for Mr. Lunsford, and that notice was given to Mr. Lunsford, in which he was responsible to inform this board of when he applied. It's not a coincidence that Mr. Lunsford left the state of Kentucky after the indefinite suspension in July to submit to a fight here for the first time in many years in September. As you see, the applications not only didn't have the indefinite suspension listed, it also contained inconsistencies on what discipline had ever happened. Additionally, the 15-day suspension that Kentucky identified from 2006 also was not listed in the application submitted by Mr. Lunsford, but rather a 30-day TKO suspension that there's no record of ever occurring. Additionally, while asthma and shortness of breath can be parsed apart, it's easy and reasonable to say that a judge or an inspector for the state would want to know this type of medical history in its combatants in case there was an emergency and in case something needed to be done with medical services. But rather, we have an inconsistent collection of documents in which the only person who admits the asthma is a licensed medical professional. In order to combat in this state, or to be a combatant in this state, it is required that all information be provided to this commission so that we can ensure that there is no outstanding discipline and that we do not have someone who is, whatever reason, losing multiple bouts in a row, or who feels that the game is inconsistent or slanted against them, as Mr. Lunsford stated. If all the information was provided by Mr. Lunsford as he swore he would do on the front end, this license would not have been granted. Mr. Lunsford would not have fought on September 17, 2016, and we would still be reviewing the application seeking get his suspension lifted in Kentucky prior to granting that license. Because of that, we ask that this commission take in light all the information provided to us by Kentucky and in the applications and revoke Mr. Lunsford's license today. Mr. Lunsford can reapply if he wishes with a complete and accurate application, and hopefully also have that suspension lifted. And then he can maybe come back before this commission and request to fight in the future. But as of now, the information provided is inconsistent, and we have a boxer on our registers that our southern neighbor would not allow in a ring. For that reason, I ask that the license be revoked for Mr. Lunsford. In addition, the costs of this proceeding and any investigation be assessed against Mr. Lunsford. Separate violations of our statute regarding fraud and deceit in application, as well as material misstatements. Thank you.
Thank you, Ms. Page. Now, Mr. Lunsford, we've concluded the evidentiary portion of the hearing, so I'll remove you from your oath at this time. Do you want to make a closing argument to the commission? All right.
Give me a moment as I gather myself. Oh. Well, I fought in Tennessee, including every state border in Tennessee. None of which I was carried off on a stretcher or had to seek medical attention afterward. As well as any professional contest I've competed in since then. I on 2 feet and I walked out. All information I submitted was the proper and truth as far as my mental standing at that time and today. The commission was well aware. If they can pull up this fight facts form, then they were well aware of any stoppages prior to my licenses. The commission, this is, the cloud is there, They have that information at the palm of their hands. I mean, flipping through cell phones, tablets. They know how to find that information. I wasn't raised in a legal setting, nor a government worker, nor was I raised by a government worker. I worked 4 times I was 16. Well, I felt myself trying to do so in the middle of a battle between it wasn't a great time as far as the sport. Now, also, to put on a fight, to be a fighter, takes a lot of legal actions. I have no legal education whatsoever. So I find myself to be overwhelmed at times. And as far as what happened in what state, as far as what they have written down, or what they have documented, I don't even know how to get my hands on that information despite jumping in my car and driving there. And I'm a working man. I live paycheck to paycheck. I don't have a legal team behind me to protect me from promoters and referees and judges. Walked out to other people's shows, went to other states. They used me as an opponent. They put me in there to lose. They used my name to give someone else one. However, I am out of shape since this arose. But I have numerous videos prior to this show, prior to this fight, in this contest where I would run 3 miles a day. I would punch with every step, spar 30 minutes a day, hit a heavy bag 15 minutes a day, lift weights, and numerous other things. Was in shape, have worked hard.
All right, Ms. Page, Ms. Page, do you have a proposed order for the board?
I do, Your Honor, proposed findings of facts and conclusions.
Conclusions of law. If you'll distribute that to the board. Members of the board, the state has the burden of proof of the allegations in the notice of hearing here. Mr. Lunsford is not obligated to disprove those allegations. The state's burden of proof is to show by a preponderance of the evidence that the allegations are more likely than not true. So the state's burden is to tilt the even scales just a little more in favor of the evidence, in a little more favor of them than Mr. Lunsford's case. He doesn't have the burden to prove anything. The state has provided you a proposed findings of facts and conclusions of law. You may use those as a guide if you find that those specific facts have been proven in our hearing today. Then you can certainly adopt those. You can adopt them in their entirety, but I'd caution you, you're not to adopt those as a finding unless you independently make the determination that that was in fact proven today by our evidence. Our evidence consists of the 5 marked documents that you've been provided and the testimony of the 2 witnesses who have testified here and the affidavit that you received, which was one of our marked exhibits. So, and I know you don't get a lot of these contested cases, Mr. Hanna, I'll turn the matter back over to you to deliberate. Your 4 tasks at this point are to make the determination, the finding of facts, determine the conclusions of law, determine what, if any, disciplinary action is appropriate, and lastly, to make a policy statement reason as to why you either took or did not take any action, or why you acted the way you did. Now, the state's attorney has provided you the proposal there, and you can certainly go through those. Most boards go through those facts one at a time to see if there's any objection to them. If it's been disproved, there's discussion, maybe some modification to each one, and then once the members are happy with the modifications, vote to accept those as are or with those modifications. So that's the typical process that we see boards and commissions go through. So with that, Mr. Hanna, I'll turn it back over to you for deliberations.
Your Honor, this takes place in real time? Or?
Yes.
Okay.
Yes.
All right.
The Open Meetings Act requires the deliberations of the commission to be in public before the parties. Yes, sir.
Can I ask the defendant one question?
Certainly. Ms. Page, any objection?
No objection, Your Honor.
The board does have the authority to reopen the evidence once it's been closed, but it will require a vote of the board members. I know that's kind of a perfunctory thing, but that's what the statute requires. So you have a motion, Mr. Chilcott, to reopen the evidence?
I wanted to ask him what other questions. Anybody want to second?
So we'll make a motion that we reopen
Reopen
questions.
the evidence, right.
I'll second that.
All right, then you vote on it?
All in favor, say aye.
Aye.
Sorry for the technicalities, but that's the process. So the evidentiary record's been reopened. Mr. Lunsford, if you'll raise your right hand, I'm going to place you under oath again. You can stay at your seat there. Do you solemnly swear or affirm tell the truth and nothing but the truth, so help you God?
Yes, sir.
All right. Your question, Mr. Chilcott?
Mr. Lunsford, today, are you still wanting to pursue fighting, boxing?
Well, honestly, say the truth, the risk isn't worth the reward. You train, you invest thousands of dollars on an annual basis. You might get 2 fights a year with a $1,000 purse. If a man spent $5 a day for 5 days a week for 52 weeks a year, you know, do the you're looking at, let me think here, 5 days a week. If I were 25 times 52. 25 times 52. Right. Now you spend $5 a day just in fuel to drive to the gym. You spend probably $40 a month for gym fees. I just paid $69 just for a double-end punching bag and hit it home.
Mr. Lunsford, we're getting a little far afield here. The question was, do you still want to pursue your license here?
I would like to know that I can. Yes, there are a few opportunities out there. I've actually had some pretty big names looking my way.
All right, I think you've answered Mr. Chilcutt's question. Is there any other questions from any other member of the board?
If I may, and
Certainly.
correct me if I'm misfollowing procedure, I would like to ask Attorney Kopchak, excuse me, one question, if I may.
Certainly. Mr. Kopchak, come back up to the record's been reopened, and he is our other witness, and he can certainly testify. Mr. Kopchak's still under oath. So your question...
Well, the question is this, and just clarification, and I may have just heard wrong. I believe at one point, Attorney Page asked you the question about does disciplinary action, are those included on the application process? And if I heard correctly, your response to that was often. So does that mean that sometimes it's not asked?
The question, as I understood it, was generally speaking with all of our programs, but with Tennessee Athletic Commission in particular, then the answer is yes, because it's on the application.
Okay, all right, thank you for that clarification.
Any other member? Mr. Hammond?
Yes, sir. I know we had the opportunity to ask Mr. Lunsford some questions, but I might have missed it. Ms. Page, if I may, our counselor. Mr. Neal, Todd Neal from Kentucky, who's given his statement, how was the communication provided to Mr. Lunsford that he was no longer licensed in the state? Because obviously there's a huge conflict there of...
We don't have that information in the record, unless it's in his affidavit. All right, well, let's look at that.
Was it mailed? Was it emailed? Was it...
Look at the affidavit, Mr. Hammond, and see. Ms. Page can't answer that question for us. Now, Mr. Lunsford may have some information about that. I think you're referring to paragraph 9.
Yes, Your Honor.
Paragraph 9 and may answer your question there, Mr. Hanna.
So is it okay for me to just, one last time, Mr. Lunsford?
Certainly.
It says that due to the incapacitated from the fight, being incapacitated, you were unable to sign that form, but he had taken great steps to make sure that verbally he had communicated that suspension to you. But do you recall that at all?
Mr. Steve Hammond, that is an absolute lie, is what that is there. I had no formal notification of any indefinite suspensions from Todd Neal or the Kentucky commission up there, their athletic commission, and I had no notification of any informal. As I said, I did receive notification of the mandatory 30-day suspension after a TKO loss. That's the only notification I received. I had no formal notification of any indefinite suspension until the case arose.
Have you answered his question, Mr. Lunsford? Any other questions, Mr. Hannah?
No, sir.
Anything else of this witness, or, Ms. Page, do you have any cross-examination of either of these witnesses on these topics?
If I can cross Mr. Lunsford, Your Honor.
Certainly.
Mr. Lunsford, did you have a licensed second at your fights in Kentucky?
No.
So again, it's your testimony that Todd Neal put into a sworn affidavit a lie.
I didn't bring one to the fight. They supplied me one.
And is it your understanding, do you understand under Kentucky law that your licensed second acts for you when you're incapacitated?
I had no agreement with any, because there's no mandatory, yes, that's a complete lie is what it is. It's, and,
You've answered your question, Mr. Lunsford. Other questions?
And Mr. Lunsford, do you have access to fight facts as well, don't you?
well, I can Google my name and put box record on it, and it shows me what my record is, but it doesn't really show, as far as I know, of any suspensions or any indefinite suspensions, and I had no real prior reason to look at
Now,
it.
Mr. Lunsford, the Fight Facts is a website.
Yes, Your Honor.
So the question was, do you have access to that?
I have no membership to it.
All right. Other questions? No, Your Honor. All right. Any member of the board have a question before we get back to deliberation from either witness? That's a no. All right. So we'll close the record, evidentiary record the second time. And members of the board, I'll turn it over to you to deliberate, and you can start with findings of fact and work through those facts and see if you believe the state's prove those or not. And then I'll just turn it over to you to discuss those things.
Going to go through these one-on-one, just openly.
Openly discuss them. If you get the one that you've got an issue, I'd encourage you to discuss that.
Okay.
Modify it.
Item number one, the respondent is licensed with the commission holding boxing combatant license 2536. That seems to me to be pretty accurate. Item number two, in order to become licensed, respondent submitted an application on September 17th, 16. This application includes a form called Combatant's Pre-Fight Physical Examination Report. We've been given that report, so I think we're good there. Question 3 on the pre-fight physical exam reports reads, are you on suspension from any other boxing commission? Respondent responded no.
Chairman, I assume that as you're reading through these, that certainly I'm not going to have anything to say unless I disagree with what's stated in the findings of fact. So assume that's what we need to do, and so that the chair continue.
Item number 4, respondent's response was false because respondent's Kentucky license was indefinitely suspended due to 6 consecutive referee stoppage losses. None of these 6 fights lasted beyond the second round. here that I think was exhibit number 3. All right. Question 5 states that question 6 on the physical exam report reads, do you suffer from shortness of breath, pound, parenthesis, palpitation of heart, any paid, sick, or pressure in the chest, or have you ever been told that you had any disease of the heart? Respondent responded no.
Mr. Chairman, you know, there may be some gray area in there, and you know, I given the benefit of the doubt, maybe the Lunsford may have not stated yes because in his belief he does. So that's a gray area for me.
I'm going to agree with Commissioner Smith. As we were going through this process, it seemed to be a little bit of confusion or gray area myself. I detected. Item number 6, respondent's response to the above question was false. Respondent's physician indicated respondent does have a history of asthma. And again, I think there was maybe some confusion around that. Yes, sir.
Have to determine now, did the state prove by preponderance of evidence, weighing what proof they put on Mr. Lunsford's testimony, the applications, and for what you've received, the state prove that he gave a dishonest response? So you may want to stop now and discuss that specific issue and then call a
Thank you, Your Honor. So let's, question 6. Exhibit 2. I'm just going to read that once again. Do you suffer from shortness of breath, pounding, palpitation of the heart, any pain or pressure in the chest, or have ever been told that you had any disease of the heart? And the answer is no. And then we'll need to statement. Exhibit 2.
Sorry.
10 of Exhibit 1. This was appears to be completed by Michael David Lunsford here as it reads. In physical history, the box asthma has been checked, and below that, because it says if you've checked any box, to please explain below. It says moderate persistent asthma without complication. Looks like that may be to read managed with, and I'm going to assume, I can read that albuterol is one of them, I can't read the other. So, again, Exhibit 2, question 6, basically is asking, do you suffer from shortness of breath, pounding of the heart, any pain, pressure in the chest, sleep, I've been told of any disease of the heart? The answer is no.
6 is tied to that, so the question is, did the state prove that that was a false answer that he gave? So that.
Chairman, you know, again, I think it's a gray area, and I do not think the state proved that that Mr. Lunsford was being dishonest when he responded no. I do not feel the state proved that.
I think it's a little bit gray. Needed to be a little bit more pointed out with exact details. It's a little bit shady. I don't see to be able to.
I'm going to agree, Your Honor, so I'm going to answer no to that question. But the,
So I would suggest a motion based on the commissioner's statements. Someone
That come at the end, or is now the appropriate time?
you could do that at the end.
Okay. Now, since, just another point of clarification, Mr. Chairman, since 5 and 6, those two questions are related, and we've had the discussion, do we need to talk about question 6? That's a question.
I'd move on to 7 at this point.
very well. Question 7 of the proposed finding of fact and conclusion of law reads, on respondent's boxer application form, respondent answered yes to the question, have you been suspended by any state athletic commission or other sanctioning authority? However, respondent stated on the form that the suspension was only 30-day mandatory suspension following a technical knockout loss, also known as a TKO.
Question 8, Mr. Chairman.
Respondent's response to the above question was incomplete because respondent's Kentucky boxing license was indefinitely suspended by the Kentucky Boxing and Wrestling Commission due to 6 consecutive referee stoppage losses. Item number 9. Respondent's response to the complaint stated that he had passed all physical and medical examinations in Kentucky and had been asked the Kentucky Commission to reconsider his suspension. This implies the respondent was aware of the nature of the suspension and the requirements to have it lifted. Item number 10, respondent's indefinite suspension in Kentucky was never disclosed to the commission. Rather, it was discovered on fightfacts.com by commission staff.
Right, so the board has discussed questions 5 and 6 and informally expressed their issue with that. So at this point, if the commissioners are happy with the others, except 5 and 6, one of the commissioners would need to make a motion to accept all but 5 and 6 as being proven true, or...
So moved. All in favor, say aye.
Needs a second.
I'll second it.
And all those in favor, say aye.
Aye.
Right, so, now, any additional facts that you think need to be in the order? Today's hearing that you believe is factually relevant to this that is not in the state's proposed order?
I don't
Mr.
think
Chairman.
so. None, no.
So, our next step for the board is to make or find conclusions of law. Now, Ms. Page has set out statutes there, and if you find that those are the only relevant to the case, then you can just adopt those in their entirety to them if you feel like there's something been left out that needs to be added.
And Your Honor, that's in addition, or so we would make that at the conclusion of this.
You've already found facts.
Yeah.
You adapted the state's facts as written with the exception of 5 and 6. Ms. Page is going to remove those.
Mr. Chairman, I would move that we accept the state's recommendation to use the Tennessee code that's stated here.
I'll second that. So all in favor, say aye.
Aye.
So now you've made your conclusions of law.
Your Honor, just as a point of order, it just for clarity, there is, in that conclusion of law, it says 3 offenses, with one of them being tied to facts 5 and 6. So if they want to adopt it as is, I would just want to draw that to your attention.
Going to need to pull that out, so I'll find it for you.
Your conclusion of law should just be a recitation of the statutes, and that part is not necessary.
Thank you.
So just, you'll just. So now's the hard part. You found the facts, you've determined that this is a statute that gives you the authority to regulate this. Now you have to determine what, if any, action you're going to take.
This is the tough part, I'll begin the dialogue. I am moved, Mr. Lunsford, by your passion for the sport. I've been in the fighting arts since I was 8, and so it's obvious that you love it. However, in the spirit of remaining consistent for all of our combatants, this commission was formed years ago by a lot of work by a lot of really good people whose only mission was to protect people just like yourself. And so it's my job and responsibility, as is this commission's, to make certain that we do just that. That said, it seems like, if I heard the counselor correct, it seems as though if you were applying today based on the information that we have, and assuming everything is accurate, I don't believe that there would be an approval. And if that's true, that would be my recommendation, would be to pull out the financial piece of this and focus on, if it's your will to continue the fight, then basically just start all over with a new application. Accurate application. And I'll turn it over to my colleagues here if there's any additional.
I understood our direction pretty clear, I think, and I hope you did, Mr. Lunsford. Our instruction was a preponderance of the evidence. So the way I understand that is that we have to understand that the state, just a little bit, proved these findings. And I think they've done a very good job of that. I'm sensitive to you being a working guy that loves the sport, and I think I heard you say I live payday to payday. I do too, especially when you're retired. It gets worse. So I would certainly agree with our chairman that maybe that's a discussion that we can have in terms of some relief with costs there in regard to, I'm sure, hours and hours that the state attorney and others have put into this process. That's costly, I'm sure. But at the same time, I want to be sensitive to you. But if I may continue, it's I would recommend, if you want to continue to compete, to reapply, and let's do this thing right. What has come to light for me, just in a way of generalization, our commission may have made some mistakes in this process, if I'm understanding everything and the way everything transpired. But be that as it may, the preponderance of the evidence has been proven. And so I would just encourage you to reapply, and which would mean going to the state of Kentucky and getting clearance there, and so it'll be a process. And
I'm 35 now, so that'll require a pretty big investment as far
board's deliberations now, and I know they're addressing some of this to you, but
So that's where I'm at with it, fellas. The state has recommended the suspension, withdrawal of his license. I don't have that in front of me, so I'm not real sure exactly how it's worded, but I think we agree on that. Has also recommended a fine, if you will, or certainly paying for these costs. The suspension of the license, and I totally agree with. I guess I'd be curious to know, when we're talking about paying for the cost of all this, what that would be, and how we can certainly do our due diligence as representing the citizens of the state, and state government has bills to pay just like I have bills to pay, but at the same time Mr. Lunsford does too. So I'd be curious to know what that cost is going to be, and I don't know if that's an appropriate question to even ask, but
well, that is, and the department may have.
We did have an investigation in this matter, and that usually is around $40 an hour. I don't recall dollars for the administrative judge, and then our court reporter costs. So the cost could be close. This is just for the disclosure of the board, an entire guesstimate on my experience of around $1,000, maybe. But that is a guess.
Hearing that, perhaps we might look at maybe splitting the difference and setting up some type of payments on time to work with Mr. Lunsford. That would kind of be my wishes, Mr. Chairman.
That's great insight, and that's one of the things I love about you. Yeah, we're not in a position to be spending the state's money, and I do agree that the amount of time that has gone into this has been a lot. So, Mr. Chilcutt, did you have any?
I'm good. Thank you, Mr. Joe. That's breaking it down. Go ahead.
So I'm going to agree with Mr. Smith's sentiments. That would be my recommendation, Your Honor, is to suspend the license. If it's Mr. Lunsford's wish to continue to fight, then make sure he takes that on himself to go through the process with the state of Kentucky, get everything worked out there, then approach the state of Tennessee if that's your wish. And if we can meet somewhere in the middle, whatever that number is, if it's close, $400, $500, which is, from a rough estimate, that's about half of what the total cost is. That would be our recommendation.
But we won't know for sure what that is, but the board, and when boards typically hear these types of cases, I sit on probably 80 different types of boards, the seem to be the best policy, if you want to do that, is to put a cap on what he would pay. And over and above that, he would not be responsible for. And you need to also address whether you want to assess a civil penalty or not.
Well, Mr. Chairman, I don't want to monopolize the meeting, but I'd make a recommendation that we suspend the license of Mr. Lunsford, that he be given certainly the opportunity to reapply as we've discussed. Further, I would recommend that his fine be a maximum of $500. And state work with him in terms of paying that, maybe 6 months, 8 months. Let me say 6 months to be clear. And then I would further that recommendation to say that no civil penalties be administered. That is my motion.
So earlier you said the cap of $500, you said penalty, but you're referring to the cost.
That is correct.
Okay.
Thank you.
So I'm going to firm this motion up, if I may, Your Honor, is to, from Commissioner Smith, is to suspend the license, and there's going to be a penalty that we're going to call it 50% of the actual cost up to a maximum of $500, so whichever is less, all right? And we're going to make the motion, as part of that motion, to not pursue any civil penalties, and I'll second that motion.
So was that your motion, Mr.?
That was the motion.
All right, so Mr. Hannah has seconded that, so I'll call your vote on it.
All in favor of that, mention aye?
Aye.
Aye.
Just to clarify, Your Honor, if I might, for our administrative purposes with the license, does this commission mean to leave the license intact and be suspended until Kentucky is cleared, or do you mean to end the license and then have them reapply? That would be revocation. I just want to make, because we can do either one, I just wanted to make sure that we.
Well, thank you. I think it was just I probably just said it the wrong way, but absolutely, the license be revoked and instead of just suspended. So thank you for that correction.
That's the motion. A second on the motion?
That's a second.
All right.
All in favor, say aye.
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 So the license will be revoked, and of course, Mr. Lunsford can reapply. There'll be a cap on the cost of $500 or half of the total cost if it's less than that, and no civil penalty. So, now the last thing is the board has to make a policy statement for its order, and Ms. Page didn't provide us one, but I'm going to offer this for you. This is the justification of the reason the board or the commission took this action. I would suggest this action is necessary to carry out the commission's statutory obligations and protect the health and welfare of the public and licensed combatants in the state of Tennessee. So let me repeat that again. This action is necessary to carry out the commission's statutory obligations and protect the health and welfare of the public and licensed combatants in the state of Tennessee. So that's just a suggestion. You can adopt that if you like, or you can come up with your own.
I like Your Honor's recommendation in terms of verbiage, and it's accurate, and I would move that this board accept that recommendation.
I'll second.
All in favor, say aye.
Aye.
All right, so did you get that, Ms. Page?
Yes, Your
All right, so you've got to draft the order for the chair's signature.
Yes, Your Honor.
All right, do you need any further clarification?
No, Your Honor.
All right, Mr. Lunsford, that'll conclude our hearing. You'll receive a copy of the order in the mail, and it'll give you your appeal rights if you want to pursue some other avenue. And so we'll stand adjourned at this time. Thank you. Thank you for coming, Mr. Lunsford.
Okay, we're going to,
I'm done. You were done break, or?
thank you so much for your help. This is actually a first, I'm pretty sure, in the 7 years, or 8, whatever it's been.
This is the first one you've had?
It is.
Because I had one about 14 years ago, and I had to have one since. Now, I believe it was a boxing and racing commission back then or something.
Oh.
It was different. It seemed like a different name, but anyway.
Well, you were great help. Thank you so much.
Thank you.
Gentlemen, would you like to take a 5-minute break, or do you want to just push on through?
5 minutes sounds good to me.
Okay. All right, then we'll just,
We'll take a quick, 2-3 minute break, whatever, yeah. Just a,
Good.
okay.
I'm thinking,
We're hopping around a little bit, but I think we are back to reading of the minutes. Is that where we are?
Yes, sir. If it's okay with you, Chairman, if we can, just so we can get as many folks out of here as possible for that rush hour traffic, if we can just hit the legal report. And then we also had a gentleman here that would also address the board, and I'd like to just kind of honor his time and then get him next after that, if that's okay with you folks.
All in favor of that?
Yes, sir.
All right, thank you. Now for the legal report, if you check your iPads, and you, of course, were able to look at that in advance as well, and then legal will just jump on in from there.
Good afternoon again, members of the commission. As you know, Matt Reddish has left us and joined Waller Law. We're very excited for him. And Liz Goldstein and I have been asked to step in his stead for the department. So this is Liz Goldstein. We've previously worked with the Motor Vehicle Commission, the architects and engineers, and the accountants. But we're very excited to start learning the TAC programs and laws and rules. So we hope that we can serve you in the same capacity as Matt, and he is available to us. We've been teammates with him actually in other programs for 2 years, so he's made sure that he's available to us while we learn. So we appreciate you allowing us to come on in that capacity, especially starting with a hearing. I know that's tough. But we do have 2 entries today on the legal report for your review, and I wanted to ask how you all like to usually do this. If you'd like to review them or if you'd like me to read them. I wasn't sure how you usually like to proceed on these.
I think historically, we've had you read them, or Mr. Reddish has read them, and from a kind of a Cliff Note version, so to speak. And if there's any questions, we can either read or ask, and then we'll look for your guidance on moving forward. And
Mr. Chairman, I don't know about you guys, but I received this. I mean, I've already read this.
you generally do read them.
So, you know, we don't want to waste your time of reading to us. I can read pretty good.
I thought you might be able to, so I didn't want to make any assumptions, so I thought so. Well, however you'd like to proceed, we're comfortable with, and if you have any questions, I'm here to answer those.
Questions from the commission board here? The recommendation is to the authorization of a civil penalty in the amount of $250 for holding a non-permitted event to be settled by consent order or formal hearing.
Mr. Chairman, I believe maybe you're looking at the second case.
Thank you.
The recommendation on the first case is up above that.
Smith, you're exactly right. For the first case, which is 201-702-991, the recommendation is to enter into a monitoring agreement in which respondent shall update this commission upon the conclusion of the respondent's action before the USADA.
We move that we accept recommendation.
And I'll second that. All in favor?
Aye.
And case number 2, outlined or identified by number 201-705-4061. The recommendation is the authorization of a civil penalty in the amount of $250 for holding a non-permitted event to be settled by consent order or a formal hearing.
I would recommend that we accept the recommendation that's listed here.
Second it.
All in favor, say aye.
Aye.
So moved. And
Members of the commission,
I
that
believe that
concludes my
concludes.
portion.
Thank you very much.
So you get to go home and we have to stay.
I have to leave you here, I'm so sorry.
Yeah, is that fair? Thank you, Your Honor. I'd be counsel, thank you.
Absolutely.
All right, gentlemen, if we can just acknowledge Vincent Ramsey, and before Mr. Ramsey, if you can just come up right here.
Mr. Ramsey, welcome. If you want to just speak into the mic and let us know, for the record, who you are and...
Vincent Ramsey. Yeah, I'm a firefighter.
Let me just give you an introduction of why he's here today and what's before us, and then from there on, if you have any questions of Mr. Ramsey, I'm sure I'd be glad to assist in that regard. Mr. Ramsey, he's come before, or come to office for the better part of 10 years from one of our admin managers from back when it was Athletic Commission and Racing Commission, said that he's coming, but always it was an incomplete application. It wasn't until recently that a neurological doctor did sign off, which kind of put us in a position where we have to make a decision at this point. We just kind of deferred that decision because we had an incomplete application at that point. But when I looked into the statute, I'm going to give you the statute that for which this is a denial of a license, and then he has the statutory right to appeal that denial if administration so denies that license. So that's why he's here today. And so I'm going to give you the statute for why, the authority for that, and then the facts behind that, and of course, allow him to speak for himself in that regard. 68-115-206 is the executive director shall have the authority to examine the professional combatant's record, experience, skill, and physical condition. It's not on the iPads, I apologize. I'll give this to you right after, and if you need to take a look at it and refer to that. Physical condition pursuant to the powers granted to in this chapter, and may deny the issuance of a license. Nowhere in there does it speak of an application. It just says you can examine their physical condition. In the executive director's opinion, so that's the burden of proof, just in their opinion, the combatant's record, experience, skill, and physical condition indicate the combatant is unqualified to participate in professional contest of unarmed combat. The applicant may appeal, and that's why he's here today, the executive director's decision to deny the issuance of a license to the commission, and the appeal shall be heard in a timely manner. This board meeting, that's why he's here. Also, Part C of that, you have Part A, which is what I just quoted to you there. Part C states, and this is when it gets into an application. It gets beyond that as well. It says an application for a license constitutes a request for a determination of the applicant's general suitability, character, integrity, and ability to participate or engage or be associated with a contest of unarmed combat. Obviously, there's a little more latitude because we're not handing out real estate appraiser licenses or land surveyor license. People are putting on boxing gloves, and they're entering into rings of professional of combat. So the burden of proof is on the applicant to establish to the satisfaction. So up against the opinion of the executive director for general suitability of physical condition, the burden of proof would lie with the applicant to make that determination to say, yes, I'm capable, and that's what he's going to attempt to do today. And basically, my statement to ASHA when he was presenting his application to us at the time was that I had questions of his suitability and his ability to engage in unarmed combat. It was in my opinion, based on Part A, that Mr. Ramsey's physical condition renders him unqualified to participate in unarmed combat, and that was the reason for my denial of the issuance of this license. I did not accept Mr. Ramsey's application primarily because, and we can explore that as a possibility at the end if you so desire, but I did not want to take his money when I knew the end of the result of this was going to be a denial. And so, and the physical condition, in my opinion, there were some things on the medical record which we're not gonna go into that. There's some question there, but that's not really the issue. The issue is just upon our observation of his repeated trips into our office. Just there was some stammering, unsteadiness of feet, and he would be the right now of record. I looked this morning. Obviously, we can consider, part of our boxing severity index takes in activity, boxing age itself. We can ask for a neurological examination past 35 as well. If he was granted a license, he would be the only active boxer over the age of 50 that would have a license at this point. But even with that aside, obviously, you have to look at general suitability. You can consider age in our sport, and we do with our boxing severity index, but that's not the totality of the circumstances for which we make our decision. The decision is general suitability. That's pretty broad in an opinion. And so based on just our observations of him coming in the office, it was determined that we did not feel like he would be in a position where we, in protecting the health and welfare of the public, that we, in good conscience, didn't feel like we could put him in a ring.
Can I say something?
Yes, sir.
Action speaks louder than words. And you don't know that. You never seen me fight before. You never seen me spar. So how you want to get that with accusation? You never seen me in action.
Mr. Ramsey, if I may, when you say you don't know me, like tell us. I'd like to get to know you. Tell us about
But
yourself.
I wouldn't be here if I couldn't fight. If I couldn't fight, I wouldn't be here. I'm wasting my time. You can't judge me by looking at it. You get to see something. You ain't see the facts. You ain't see why you watch me spar or something like that. You can't just make these type of accusations. You see, you don't know me. I'm not gonna...
Can you help us know you? Tell us about how long you've been boxing, where you train.
Since 1980 in Fort Valley, Kansas. So boxing, I was in the Army. But I'm saying I'm a very good fighter with our boxing skills, speed, and punching power. You know, I can fight. If I couldn't fight, I wouldn't be here now. I wouldn't be putting myself on the board right now. But waste the time. Try to get my life to fight if I couldn't fight. See, you had to see me inspire, watch me fight first. If I get my ass before we get knocked out, then what can I say? If it happens, it has to happen.
Mr. Ramsey, do you have any video footage you can provide us with, or?
Well, hey guys, I'm going to watch me work out at the Golden Glove Boxing over here on Kentucky Avenue, I believe. Justin. The guy white guy named Justin. You know him? Well, he had to do over here in Kentucky Avenue. He watched me spar. Well, we got to do from there. But see, nobody never knows me. See, I knows me, knows I can fight now because I'm a fought in Nashville. I never fought in this city before. I always wanted to, but I never fought in Nashville.
Mr. Ramsey, am I hearing you correctly when you say you train currently at the Golden Gloves training facility?
Yeah, got the white guy, we got his name. They on Louisville Road, we got his name, Johnny Broadway.
Donnie.
Johnny Broadway, yeah. And you know, I was spot work out first, and then you make that accusation. But you make that accusation because I'm a very good fighter. With a lot of boxing skills and determination. You see, anyway, why we spot first? That's what we do in California. We guys trying to get boxing. Somebody out in the gym watching work out first. See how they look.
Mr. Ramsey, when's the last time you were able to train over at the Golden Gloves facility?
I was there about 2 or 3 months ago.
2 or 3 months?
Yeah.
And are you just on a little break right now, or are you
I'm going back down to Johnny Broadway. Yeah, on another little road. I can go to the Golden Glove gym too. He costs a little more in his gym. Hey, Johnny Broadway ain't been training for free. And,
Mr. Ramsey, does Donnie know that you are trying to get a license with the state
he
police?
knows I can fight. He asked me, he knows I can fight. He knows it.
So he knows today that you are trying to get a license with the state of Tennessee.
Yeah, he knows it. He knows I can box. He seen me box down in the gym. He said himself I'm a good fighter. He told me that he knows it. Johnny Broadway, white guy, with a little hat. You know what I'm talking about.
I know him well.
Yeah.
I must say, Mr. Ramsey, I'd be a little surprised if Donnie knew you were up here today trying to get a license to compete. That would surprise me, the Donnie Broadway I know.
Yeah. He knows it.
Okay.
Yeah. I never fought in Nashville before. I never did. I always wanted to.
Let me ask you this: do you what I've learned, and you and I are probably pretty close to the same age. What I've learned in my life is that I can't keep what I have unless I give it away. Let me say that again. I can't keep what I have unless I give it away. You know, I had to get to the point to where, I had to give it away, and started working with young people and sharing my experience, strength, and hope. And are you doing any of that?
I hope I can get another chance to do it. If it doesn't work out right, then just do it. Do something else. I had no problem for in the past, but I'm still doing it. But I think it's possible. In about 2 or 3 more years, I'll fight for another American title, championship. I'll be a super welterweight championship title. It's possible. Maybe it's possible. If I don't get injured or nothing, or I get beat, who knows?
Mr. Chairman, if
But if I lose the fight, I lose. I win 5 fights, I feel. If I lose between that time, I plan to just quit.
Mr. Chairman, respecting protocol and giving Mr. Ramsey an opportunity to say anything he wants to say. Is there anything else that you want to share with us?
If it doesn't sound right, give it up.
Mr. Chairman, I'd like to make a motion that we accept the recommendation of our staff that we, at this time, deny this application with Mr. Ramsey having an understanding that he can appeal that. That is my recommendation.
I second it.
All in favor? Aye. Say aye.
Thank you. It was denied, so this would be the appeal. There's not like another appeals process. It's unlike the formal hearing, that we just went through, since it was administrative in nature. So just understanding that you may, upon deliberation, if you, the motion would be either to accept the denial or to accept the application, which would put him on a path, potentially. He still has some hurdles to overcome based on some of the things we saw in the medical still, for that to happen. But if those hurdles were overcome, we'll say that hypothetically if they were, then that would put him on a path towards licensure. So it's either, do we, upon hearing that, did you want to reconsider the motion, or is there another motion you'd like to put in, or?
Let me withdraw the motion I just made and make a motion that we accept the staff's denial. Period.
Second it.
All in favor? Say aye.
Aye.
Mr. Ramsey, I appreciate you being here today. Thank you.
Mr. Ramsey, go up there and help Donnie Broadway. There's a lot of hurting kids, young people that need you. You can go up in that gym and you help him with those young people. Those young people need a man like you. Go be their mentor, share your boxing skills, and let me tell you, you make a difference in those young people's lives. So you get up there and get busy. You hear me? Thank you for coming.
What about me fighting again? One more chance. One more chance. This is the last chance. One more. It's not going to hurt. One more fight.
We've concluded this portion.
License all these years. Every year I take the boxing license. I pass the new exam. I pass all the requirements.
Ramsey, if you want to discuss further in our office after this, we're done with this portion.
Yeah.
But you're welcome to have the discussion what the ramifications of what that decision was, and more in particular, if you'd like, in private. So, but we're done for today. Thank you for coming out, and we'll discuss further if you had any other further questions then, okay?
Thank you, sir.
Thank you, Mr. Ramsey.
All right, so
Yes, we're moving to the June minutes. We'll just pick up from there, from where we left off.
all right, and I think those have been provided by, we've got the tablet here that we'll take just a quick minute to run through those if there's any changes or
Yes, sir.
amendments, what have you, then we'll speak about those. Otherwise, we'll need to accept these into the today's.
Mr. Chairman, I have personally have read these minutes prior to coming today, and I would like to make the motion that we approve the minutes as stated from our previous meeting.
And I'll second that. All in favor, aye?
Aye. Thank you, gentlemen. If we can move to the next item on our agenda, that would be the budget report.
Mr. Chairman, I read this thing, and it's probably the reason why my wife balances my checkbook instead of me. So I've just asked that Mr. Copchak just kind of speak to this a little bit and help me to understand the great information that's obviously presented for us, but my wife's not here to explain this to me.
You and I have the same arrangement. My wife, she helps me with this as well. So, and I'll confess I got some help from our accounting director as well, just because there's some questions I had, and so if I had them, you probably had those as well. So if it's okay, I'm going to try to give you a deep dive and kind of explain those itemized lines. Now, you're probably wondering why I gave you two budgets. One is for the last fiscal year, and which we've already been tracking at our meetings. We've been tracking those, but I just didn't feel like it was sufficient to put that in context with 1 month since we just began the next fiscal year. So that's why we have two there. We've already gone over the first fiscal year, but I put it there for your reference. But if you will indulge me, we'll just go ahead and we'll discuss those items, okay? So we'll start with revenues, what they are, and then we'll give the sum total of that in our second portion, and then we'll talk about expenses.
Mr. Copchak, let me interrupt for just a second before you even start that. The trend column that's color-coded, I'm assuming, correct me if I'm wrong, that's like the calendar.
That would be, yes, over the fiscal year.
Okay, thank you.
That's right. We'll start with revenues. Licensing revenue is pretty basic, pretty self-explanatory. That's just what comes in from applications, renewals, and the like. Case revenue, that's going to be your civil penalty and recoveries, kind of like what we did today in the formal hearing. There wasn't a civil penalty assessed on that one, so that still won't show up in that column. And like Chairman Hanna discussed, those are rare. So as you can see across there are none. So that's why there's nothing there coming in. So you're right, they are rare. State reg fee. You're probably wondering, what is a deficit showing up in a revenue slot, right? That's kind of weird.
Thank you.
Well, that's the state reg fee, and what that is we pay $5 per year per license for each and renewal. Okay, that's just administrative costs. But why are they in the state and revenues rather than the administrative cost backs? Well, the reason why that is because Commerce and Insurance can't print those licenses out ourselves, so we do that. Finance and Administrative, our partners over there, do that for us. And so as a result, since we can't bill those fees directly, and since it's a workaround, it's just it's put in the revenue because it's really considered like it's a reduction of revenue rather than an actual expense. So that's why it's put there. So that's why, and that's so you take out about $5 per license, divide that by 5, and you get an idea about how many licenses were printed that month. Renewals, applications, all that kind of stuff.
Why can't we print those? We just don't have the technology, the equipment,
They didn't quite flesh that one out, so I imagine there's some probably bureaucratic hurdles, that's my assumption.
I'm so surprised.
Yeah, I'm shocked. But there's, so as a result, since a true reduction in revenue, they didn't want to itemize that as an expense, but that's what that is. And it's kind of helpful because you get an idea about how many licenses were printed out each month as well, renewals and licenses in particular. Now, the expenses, you have your Edison expenditures, which are basically payroll. All right, and that's assessed based on items such as typically that share is determined by license count, number of complaints, and the budget plan. So That's not real large with Tennessee Athletic Commission because there's not a whole lot of licensees in that regard, and we'll kind of drill down a little bit more when we get to administrative costbacks. So, well, administrative costbacks, we'll just touch on it. Basically, that includes the tax share of the liquidation of all administrative costbacks from all the programs. The share is determined by license count, number of complaints, and budget plan. And just to give you some perspective, which accounts for 0.44% for TAC versus 16% for Cosmo and Barber. So we're not even at 0.5% of that budget, for administrative costbacks. Administrative costbacks are like travel, printing, all the stuff that you would do that you would do to facilitate your business. And so, that could always wait if we get, like for example, Cosmo and Barber has 60,000 licensees. That's why they're 16% of the budget, whereas we're a smaller portion of that. So to break that down into hard numbers, which resulted in $765 in administrative costbacks. Like if you go to the next screen of our budget, you'll notice on administrative costbacks, we have $765 listed there. That was our share of the total of all the programs, administrative costbacks, our cost to do business. And so that's where the 0.44% comes out of. And that was our share of the total of $175,750 total expenses for program expenses across the board. Our program is covering $765 of that $175,000. And again, that's based on licensing count, number of complaints, and budget plan. So that's what that is. If you one thing you will notice, and then this will kind of segue into our next topic of discussion, is look at field enforcement for both of them. Field enforcement are inspections guys. Those are the ones, I went to a fight.
And fiscal year and the new year?
Yes, sir.
Okay.
Mm-hmm. And if you notice, we spend a lot of our time in the red, but we have come out of the black. We'll have some fights because of the gross receipts that, fortunately, like last year, put us back into the black. But what really is the killer in the budget is the inspections. You'll see that across. That's what's dropping us in the red every single time. And that was no difference here as well. If you look at this fiscal year of July, that second page of your budget, field enforcement, you saw our total revenue was $2,385. Costbacks, just general cost of do business, wasn't really that significant. Payroll wasn't that significant. If you notice, we're based on program size, the payroll wasn't that high for the month. But field enforcement is what nailed the budget and dropped us back in the red.
If I may just make a comment there, I know we can't do nothing about what I'm about to say today, just an observation, if you will. I think we've seen too many inspectors, and I think that we got to figure out a way to maybe have some sort of duplication of services, because many times those inspectors come in and they do a duty for 10 minutes and the rest of the night they're just sitting there. And so that's something I hope that in the future, rulemaking, whenever the appropriate time, that we can have some real discussion about that, because when I look at this figure, and I understand it's necessary, we're following our rules and our statute, I understand that. But boy, that's something we need to visit, because the shows that I've been to, and I've watched those field inspectors, and my goodness alive, we're spending too much there, in my opinion. So that's a conversation we can have.
Let me ask you, because that's such a great point. And the last fight I went to, I think, was the UFC fight, and I haven't actually shadowed an inspector in years, but if I'm not mistaken, the inspector, once they're assigned a couple of fighters, they're pretty much with those fighters all night, correct?
That's correct.
Yeah. So, to your point, Commissioner Smith, I wonder if we couldn't entertain the notion of having fewer qualified inspectors, because not any Joe Schmo can come off the street and be an inspector. They got to know the sport and how to rap, but we could have maybe an environment where we have fewer inspectors who are going to conduct their responsibilities, which is making sure the wraps are right, the gloves everything's checking off. But then we could assign more of a volunteer to sit with those guys for the remainder of the night. It's just an idea, because I know a lot of people, and there would still have to be a qualification process to vet out a qualified volunteer, but I know a lot of people, just for the sake of getting the backstage pass to be able to hang with fighters, would be happy to do that. And most of them would be MMA guys and boxers.
Well, I'm glad you asked.
It's just something.
You just you set me up for the segue.
Okay.
That was the update I was going to give you on our part-time inspectors.
Okay.
Now, one thing I will say, and you both make great points, and to your point regarding about how they can't leave the fighter, that's really the issue. It's we'd love to duplicate tasks, but they can't do that outside of proximity. You know, if that duplication could happen within the same proximity, then we're always looking at that. But I went to a fight on October 15th, and we had 4 or 5 inspectors that could not leave their posts. And the reason why is because you had the 2 corners, which every single between each round, they're checking to make sure nothing's going into the bucket or coming out of the purse that's not supposed to be there, you know, the bag. So you had that issue. They couldn't leave their posts. That's 2 folks right there. And what really kills us on the inspections is the dressing rooms, because you have to, however many dressing rooms they have, you have to have an inspector in each of those. If you had 1 dressing room, that's 1 inspector. That would work out great, depending on volume, of course. And then, of course, some of these bigger cards too. You know, because even in 1 dressing room, if you have, you know, a card that's got, you know, a pretty lengthy list, or and they have their own formula that they work out, but may require another inspector, because then they have to make sure that they don't change the wraps, or so they're not being distracted away from what they have, you know, their gloves or their wraps.
Mr. Kopchak, you know, in the sake of time, I didn't mean to open up Pandora's box. I think there'll be appropriate time to talk about all this. I'm going to get us back to the budget, but I did just want to say that this is something I think we need to take a look at, and at appropriate time we need to have some thorough discussion. Quickly, I was at Madison Square Gardens a couple of months ago and had a big HBO event and 2 world championships, and it was incredible, the machine they had with a few number of people. So I've got some real thoughts and ideas to that, but today's not the time to. So I would ask, excuse me for opening up Pandora's box, and just something moving forward I want us to take a look at.
No, that's great. We always welcome those comments.
Yeah.
You have a wealth of wisdom, and that's why we come to the board in that regard. So we'll definitely have that discussion. And one thing I will say about the part-time inspectors, I just want to give you an update on that. They have hired 2 part-time inspectors, and they've approved 6 more. They forwarded to Human Resources for their approval. So that puts us 8 towards the 15, and that'll save us quite a bit of money, because if you have somebody in that locale that you're not paying for per diem or travel, you're not putting them up at a hotel because they're there already, you know, and once they're trained and they're getting paid the $100 per fight, that's significantly different than the state rate, you know, of a full-time employee. So we will think we'll get some impact there. We'll have to see it in the trending, but we're hoping to get some relief in towards our budget. And of course, you know, as far as efficiencies and process, we always welcome those, and we'd love to have that discussion. Thank you for that, for both. We appreciate that input. Was there any questions on the budget?
So, as I understand this, looking at first our fiscal year that just ended in June, is that correct?
Yes, sir.
Just bottom line is we finished with a $45,798 surplus.
Yes, sir. Well, that's the good news, and thank you for bringing me back to my duty there. There was, let me just read that off to you so we can just kind of cap it off.
Okay.
Revenues for last fiscal year, total coming in was $151,322. Expenditures, $105,524, but we did end up in the black in surplus of $45,798. And then if, of course, you look at next year, you know, we're starting some of that trend again, but we do have some of the surplus to eat some of that and to absorb some of that. And hopefully, you know, if things work in a perfect world, these inspectors offset some of that cost and they'll come together nicely in the trend. But if not, we'll have that discussion. That's the beauty about doing a month-to-month trend, because you're not surprised. You know,
well, let me ask you this. This again, $45,000 some odd dollars surplus.
Yes, sir.
does that monies carry right over to next year for our budget, or is that used to balance somebody else's budget that didn't do so well?
It stays with TAC.
Okay, okay.
Whatever's brought in TAC, it stays with TAC.
Okay, so I got to believe that Senator Bo Watson and the governor have got to feel better about what they see now as opposed to what they saw in the previous few years.
I have a feeling you're probably correct on that one, yes, sir.
Okay. So do we need a motion to approve this budget?
No, sir. If there's only if there's any action items, then we'll just bring those to the purview of the board, and then we can move at that time.
Thank you for this thorough report, and
my pleasure.
Yeah.
There was one thing while we're in the director's report, I wanted to update you on. It's just a matter of housekeeping, but it also comes from our last board meeting. If you remember, we talked about Medlick, and we moved to use them as our vendor for our medical information. And, we had we had several letters from other commissions, Alabama, I think Missouri being one of those, as well, Kansas. However, she informed us that regretfully she's not going to be able to move forward as our vendor, and there was a development around our shop that was going to be cost prohibitive from allowing her to continue in business. And really, what it comes down to is just the operation cost to remain HIPAA compliant based on the interpretation of federal guidelines. That for her to meet that standard was going to be incredible. And so, based on some of the prices that she quoted me, based on the interpretation, and it is an interpretation, but to fight that interpretation, the legal expenses as well. So, on both sides of that, she didn't feel like she could move forward. So, she, after 8 years of building this, had to regretfully inform that she'll no longer be available to work as their vendor. So,
that's a shame, because that's a great service she was providing.
And they were all pleased, as you saw from the letters of recommendation. There was no nothing from their regard that showed any dissatisfaction in her service. So I regret to inform you of that, but nonetheless, that is the update regarding Medlick. So that's it for the budget report. And if we can, we'll move to. We've covered the legal report and the formal hearing, so proposed rules. And again, I was remiss by nature of the way things were moving. I wasn't able to introduce Miss Liz Goldstein to you, but we look forward to having her on board, and she's been an asset to us already, so we're thankful for that.
Welcome.
Thank you.
Moving to the proposed rules, have you all had a chance to review these?
I've read through them.
You've read through them? Mm-hmm. Okay. Did anyone have any questions? I'm going to give a brief overview of what these proposed rules do real quick, just for the record. These rule changes would serve to make Tennessee's combat sports rules regarding weight classes, weigh-in times, and ring apparel identical to those promulgated by the Association of Boxing Commissions, otherwise known as ABC. This amendatory language will allow the rules to adapt to changes promulgated by ABC in 2017 and will result in greater standardization of the regulation of combat sports among the states. They also create mandatory contest stoppages, which promote the health and safety considerations that will ensure sanitary conditions for combatants. And lastly, the additional application fee for those who choose to get licensed within 24 hours of a contest is designed to persuade applicants to apply with sufficient time with the Tennessee Athletic Commission in order to properly evaluate the applications. This rule change will also address concerns from the commission officials who currently collect large amounts of cash while at the contest venue. And looking at these rules, in order to be more in line with the Association of Boxing Commissions, our Tennessee statute directs the Tennessee Athletic Commission to look to the ABC guidelines, as well as federal law that encourages us to follow the ABC guidelines. The Commission has any feedback as to the changes that you've already reviewed, you can do so now. If the commission has no changes and would like to move forward with these proposed rules, we could have a roll call vote to move forward in the rulemaking process.
Let me just give you a quick little context for where these kind of came from. If you recall, our former staff attorney, Matt Reddish, who was here earlier, went to the ABC annual conference with our assistant commissioner. And it was these rules that were encouraged and adopted by the ABC. And the only thing that was different that was included here that wasn't a part of that that learning experience, if you will, that was brought back to us was the $25 that she mentioned in there for the 24-hour for the license within 24 hours. That's talking about seconds, and there's two concerns for that, and that came out of a nearby commission as well. They've adopted that in Virginia, and they seem to have some success with that, because obviously if you can license boxers, you can license referees and even judges and some of these others, and especially the boxers who have a more hardy package, that they has to be reviewed, medicals and all that, but they can get licensed before the fight, 7 days, as what is our standard now. Then why isn't a second who really just has to fill out a form, why can't they do that when they're a part of that team? So instead of having so we're trying to basically encourage, but we don't want to be, we don't want to create a financial burden on people, hence the $25. We had some discussion about that as to what would constitute, an unnecessary burden on folks. But we also wanted to encourage folks, and that's subject to waiver, if there was a situation that would warrant that. But we also wanted to have that in place so that we don't have inspections guys carrying around thousands of dollars, and they have seen less of that, but carrying around thousands of dollars, maybe some of these bigger venues where they're taking in this last-minute licensing. So, and they do typically on their card will supply a list of those seconds in advance, so we know who they are, and we're just trying to encourage them, to go ahead and do that prior to the event. That's hence the $25 there. So that's the context of where that came from and why these are constituted, or now at least constructed in this rulemaking.
This doesn't do away with the ability to issue that license the day of the event.
Yes, sir.
We're just punishing them a little bit because they didn't do it last week.
That's right.
Because that happens sometimes. Yes, okay. Thank you for that clarification.
Are there any questions from the commission members about the rules that otherwise?
You're comfortable with that? Yes,
Yeah,
sir.
if you're comfortable, or if there's some things you want to tweak and you want us to bring these rules back to you at the next meeting, that's fine as well.
Another thing that kind of ties in with the weight classes in the 48 hours before the scheduled start time. Remember, we used to do that 24 hours beforehand. We're trying to prevent those dangerous weight cutting techniques that have been kind of historically in the past been employed. So that's why that's there.
So what did we change materially about the timing of the way?
It was 24 hours, and now it's 48 hours. So we don't want them last minute right before a fight, be dehydrating themselves and doing whatever else they wouldn't typically do in that situation.
So the weigh-ins have to take place 48 hours in advance of the fight?
They don't have to. Just
they can.
We're just extending out they can.
Yeah, and that's an ABC thing. I mean, are other states doing that?
They are, yes, sir.
Okay.
That was the consensus at the annual convention. That's where that came out of.
Personally, I like that. My question would be, if adopted today, when would this take effect? Because you may have, the reason I ask that question is you may have events that are already scheduled and their weigh-ins attached from a date standpoint to that event that's already scheduled. And I think it would be a little unfair to rush into somebody and say this is effect. I mean, we got to give a period of time. So when would these, if we approve today, when would they go into effect?
Yeah, I can tell you a little bit about the rulemaking process. It can take up to 9 months
Okay.
before this rule would be effective. It has to get approved through the different channels of management in our department here at Commerce and Insurance. Then it will go to the Attorney General's office and the Governor's office, and then back to the Attorney General's office before it would be filed with the Secretary of State. So it is quite a lengthy process, but throughout the process, we send out electronic notifications to all registered licensees about the proposed rule change so that they're aware. And then we usually, when we get notified that it's going to become effective, we let them know again. So we try to keep all licensees informed throughout the rulemaking process so that they're aware of upcoming changes so that by the time the rule does actually take effect, it wouldn't negatively impact an upcoming fight.
I just thank you for that explanation. It troubles me, and it's just the bureaucrat of government that has to go through all these different levels. And it makes me wonder sometimes, why do they need the experts if it's going to have to go through all these different levels? And that's just a sideways comment. You can strike that from the record if you want to.
Well, I understand your frustrations, and I think, my best explanation would be we need your expertise, but we also want to make sure we're in line with the statute.
I'm just being a little jerk, I guess.
I understand.
A little comic relief
There you go.
In the middle of our business.
I know it's been a long afternoon. I will say, just as an update, the other rules that you had passed previously had their hearing at the government operations at the legislature, and we only had a few questions and passed with no problem. So those
That
rules
was
are becoming
related
effective
to
shortly.
that, as I recall, that was related to the state having no jurisdiction over amateur boxing.
The rules I'm referring to were the glove weight changes that you made, and what else was it?
There was, I can't remember, I think they were, I have to look at it, but maybe weight classifications. Yeah, it was gloves, and there's one other item.
Wasn't it like apparel where for the females they were?
That's on this one, I think, Steve.
It's on this one.
That's correct.
Because we had one, and I don't have my notes in front of me, I apologize, but we had one that went effective 10/15. That's going to actually go in effective 10/15. If you go on notify.gov, and when you sign up there, they'll give you those listings of what we posted up there. And of course, I can send it to you as well. It's already public information. It's already been approved. But we also had one that went in effect in July as well. So that's what she's referring to, is those two memos. One was glove weights, and I want to say weight classification for the other, but I'm not sure. But I can send those to you, actually.
So they're in the process of going through what you explained a minute ago.
Yes, those two rules have made it to their end game, and they are effective now.
Okay, just a question before we vote on this. Where is, the last time we were together, we made the motion, it was approved, that the state have no jurisdiction over amateur boxing. I had asked for advice from you guys whether it was okay for me to lobby the representatives pursuant to that motion that passed. And I was told by you and our counsel at the time that you would explore that and get back to me. And I know you haven't had time quite yet.
I can actually give you a quick update.
Okay.
It's general, because I don't have all the information and the hard data in front of me. But we actually proposed, Matt, our former staff attorney, he drafted 4 departmental bills. And the only one that went up to the Hill was the deregulation of amateur boxing.
Okay.
And but it lost traction and then died. So now, that's from a departmental, I don't know what the internal of what happened. I just know that the bare facts of that is that it went up to the Hill, and then somewhere along the way it died. Now, it doesn't mean that if somebody with the in the position to allow that to pick up traction again. And we haven't, it's not dead in the sense that it'll never be, life will be breathed back into it. We just removed that departmental bill based on the resistance that, at least as that was articulated to me, based on the resistance received for that particular one up on the Hill. Now, what that looks like, why that was the case, but we're going to track those 4 departmental bills and then revisit those in time. There's a lot of correspondence in regard to that one in particular, so there was a lot of interest initially. I answered a lot of questions in that regard.
When are you going to share this with us?
At this meeting. Because of sunset laws, we have to do that in the open forum.
Okay.
So,
it's troubling to me. I understand what you're saying, that we hadn't been made aware, that my question was never answered with regard to, was it appropriate for me as a commission member to lobby the people up there that need to be lobbied, and you guys never got back to me. That's troubling. And this is I have a real passion about this. Let me just say that, if you don't notice it. That's all that's troubling to me. And I'd like some information about what it looked like, how it was worded when it was sent up there. We never saw that. I would like to see that and have some direction about what's appropriate for me as a commission member related to that issue. I think that's fair to ask. Because I have a real passion about this. Sure. I have a real passion. And I know more about amateur boxing than you do.
Yeah, I agree.
Than anybody up there in the state that's going to act on the legislation. So, help me with this. I want to do the right thing.
I wasn't aware of your request, so I apologize in that regard. I couldn't respond to your request without knowing that.
You were in the meeting?
Talking about the last...
Mr. Kopchak, you were in the meeting when I asked.
The board meeting that we were in. Okay.
Yes, I asked that question, and you answered it. And your answer, go back to the minutes or the recording, I'm sure you have it. And your answer to me was, Mr. Smith, I'll research this and get back to you.
Right, and we have to, and that's what this meeting is about as well. But we have to do an open forum. I have to track that with other folks. I'm not the sole arbitrator of that. I put forth your interest, towards the other internal stakeholders as well, and that's why the departmental bill was drafted. Of course, I would be delighted to show that to you, but that's why it was sent up in response to your request. We asked for that, and we got movement in that direction. Now, I wasn't in those meetings up on the Hill, so I can't speak to that. But is there some other way that I could assist in that regard to
Well, once again, and I don't want to kick a dead horse, but I don't want this to die. I don't want this horse to die.
Commissioner Smith, if
Yes.
I may, really those questions are legal questions, and legal counsel probably should have responded to you. Of course, there's been a changeover recently. As your new staff attorney, I've written down your question, and I'll see if I can address it as soon as possible. I do think it's important that you want to be active and you want to know what your limits are as a board member.
It was as simple as that.
And I apologize for using the language die. I meant on this round. We've kept the departmental bills, and we believe obviously there's merit. Otherwise, we wouldn't have taken it up.
I don't understand why it would be a violation of the Sunshine Law. And I know these guys are getting frustrated. They want to go to Memphis, and I want to go to Chattanooga. So excuse me. Thank you for tolerating me. I can't understand why it would be in violation of the Sunshine Law to share information with us. We're not deliberating to an end. It's not violations. Sometimes we take the Sunshine Law too far, in my opinion. It wouldn't be a violation of Sunshine Law to share with us what the bill said that they sent up to the Hill. That's not a violation of any Sunshine, for crying out loud.
I guess I was thinking in terms of deliberation.
We're not going to be deliberating. I'm going to be looking at it in Chattanooga, and you're going to be looking at it in Memphis.
Right.
You're gonna be looking at it in Nashville, I'm sorry.
All over the state.
So, but, once the Department of Bureau was drafted, it was out of my hands at that point. So I just, I didn't want to invite deliberation and some sort of, and then back into the sunset.
I understand it goes back to legal, so just help me. And again, I don't want to feel like I'm picking a fight. I'm really not. I just have a real passion that this is done right. And the way it's set up right now is not right. It's real broke. So let's fix it. Whatever that looks like, let's fix it.
Well,
Thank you for letting me pick on you a minute.
No, by all means. I've got 4 brothers and sisters, so you kind of get tough in that.
Excuse me, Mr. Chairman, thank you.
Thank you.
Passion. I love it.
Okay, in regards to this.
Yes, focusing back to the proposed rules, are these rules something that you want to keep on the table, keep editing, keep the discussion open before the next meeting, or would you like to move forward with these rules?
Mr. Chairman, I'm okay. I've looked at this carefully before we came in today, and I don't know how I got off in the bushes. Excuse me for doing that, but I would recommend that we approve these proposed rule changes. That's a recommendation.
And if the commission would like to move forward with the proposed rules, if they could, a 2-part roll call vote, one to adopt the regulatory flexibility addendum that's included in the rules, and the second vote to adopt the rules.
So I would make a motion to adopt the regulatory flexibility. Is there a second?
Second.
All in favor, aye? Aye. And the second motion would be to adopt these rule changes as they've been presented to us today. Is there a motion?
So moved.
Is there a second?
Second.
All in favor? Aye.
Thank you, commissioners, and as your new legal staff, I will make sure to keep you guys updated on the status of our rules as they move through the process at our next meeting.
We're going to do the roll call vote for that, since of the rules.
Yes, I apologize.
If it's okay, let me just call out your names in particular, and if you could state where you stand on that. Steve,
Will that happen twice, as we just did?
on the proposed rules, or would it be the reflexive? Yeah, let's just do we had an original motion by Steve Hanna for the regulatory flexibility addendum, and then a second by Mr. Smith. So let me just do a roll call on that. Steve Hanna?
Here.
There's that aye? And that was an aye. Chad Chilcott?
Aye.
And then Joe Smith? Okay. Now for the proposed rules, we had an original motion by Joe Smith to approve that, a second by Chad Chilcott, and then let me just do the roll. Steve Hanna?
Here, and my vote was aye.
Chad Chilcott?
Aye.
And Joe Smith?
Aye.
All right, let the record show that it's unanimous. Thank you. Now for the last part of new business, unless someone would like to open it up for further business, would be the amateur event permit revision form. If you recall from our last meeting, we did state that we wanted to make the amateur event permit 24 hours. So what we've done is articulate that, but then we added a couple other items. Let me just go down that while we're editing this form, and I'll show you what those is. The red line is that this application must be submitted by the event promoter or sanctioning body. The responsibility is there, so we just figured it's best to articulate that. So that's why that's there. One amateur event permit will only cover a 24-hour period. That's what, as discussed and approved at the last meeting, and there it is in the form. It's just stating that. And then just as a matter of housekeeping and for reference, the Commission's laws and rules, we're directing them back to the site if they have any questions about that as well. So that's all that is. And then if you look in number 2, an application must include the waiver fee. That was already there. So it's a little confusing, but it's in red, that emphasis. But in the red line rules, that's confusing, but that was always there. That was at the original form. But if you go beyond that, please attach proof of nonprofit status to this application. Trust but verify. That's kind of the point there. I mean, you're claiming that. We probably need to see some paperwork into that regard. So that's why that's there. If you go to the next page, more housekeeping there is just, if you need additional room, we don't want folks to say, well, you only gave me 6 lines or 3 lines, you know, and so I didn't have any other opportunity. So that's a little blurb there to give them the opportunity to attach more if they need to. So that's what that is. So we just basically need, after deliberation or discussion, if someone wants to make a motion to either approve, deny, or amend, and then we can move on from there.
Let me just share with you that and again, my expertise is more in the amateur boxing realm than the amateur MMA. And in amateur boxing, no official is paid for their services. They're all volunteers. Now, there's a very strenuous, structured process that officials, pardon me, judges, timekeepers, referees have to go through to be certified by the national governing body to have the right to volunteer. And then you're going to show up in an event to volunteer, and you will have paid a registration fee to USA Boxing, and then you're going to get criticized for the decisions you make. little sidebar there. But I say all that to say that this is going to be hard to do for these amateur boxing shows because they don't really know who their officials are going to be, who's going to show up that night to volunteer. I mean, they just don't know until they get there. So this is going to really create some issues with amateur boxing. Now, amateur MMA may be different. I don't know. But, boy, that's the way it goes, you know.
Well, and they're not licensed, so this isn't one of those hard, fast, you know, like, because we really need the information, and it's more pertinent to pro because they're licensed.
But in this amateur application, though, this is not a pro application. This is an amateur event permit we're looking at.
Right. So that's really, I think, a courtesy to just allow them extra space to articulate further. It's not so much like we need to have everyone on that list, and no, we can't change that list whatsoever.
Okay.
Just, you know.
So when an amateur event is going to happen, and they send this in, and they list Joe, Tom, Sally, whoever, but then George, Fred, and Marvin shows up that night,
right,
they can still continue with the event.
If the sanctioning body is okay with that, then we're okay with that.
Okay. The only other question I would have, and I like this, what y'all doing with this, by the way, the only other question I would have is what happens if someone fails to send this in within 30 days? So they're getting ready to do their little, what we call smoker, and they're all volunteers, and they oh my goodness, we're a week out, and I forgot to send my amateur permit in. But they've advertised, got their hot dogs ready and their popcorn, and going to try to make a nickel, but they forgot to send this in. Can we somehow adopt some leeway surrounding that?
We already have that. In the rules, it does have the deadlines, but we've granted some waivers for folks that messed up.
Yeah.
But it was a one-time deal. Now if we had a long-time promoter that messed up, that's different. You know. But if you had somebody that truly has never contacted or touched this commission before, and it's, like you said, trying to put on a smoker or something to that.
Well, and one of the reasons I ask that question is once again apologizing to my colleagues, but we're getting ready in Chattanooga to host the Eastern Qualifier. And my daughter is running all that because I'm going to be gone. And I asked her yesterday, have you seen your permit? She said no. And this is, every amateur boxer in America is coming to Chattanooga the 16th of October. And so we're already inside that 30 days. So I think she's begun a dialogue maybe with Aisha already, but I think that's something we need to be sensitive to and understand. These amateur programs, most of the time being run by volunteers, and they're going to make some mistakes, and these shows are just trying to keep their doors open, and I think that's true in amateur MMA as well. So let's be a little bit sensitive to that if we can.
Matter of fact, we've approved one just this past week, and it was a similar situation where it was somebody that just missed a date, wasn't aware, and didn't have the benefit of maybe that experience around them. So, but it's typically a one-time courtesy.
Good. But I like the form.
There was some discussion about the athletic commission kind of not being so much involved with the amateurs and maybe the sanctioning body, being more involved with that, so we're more involved in the pro stuff. Where are we on that? That was on like the last meeting, and then the emails from you.
That's a part of that. Once we deregulate the amateur portion,
Okay.
which did have the support of executives, so I will say that you did have the support there.
Okay.
If that happens, then that would by extension be a part of that, because obviously you don't deregulate amateur, the sanctioning body regulates it, right?
Right.
We're passing the baton completely to the sanctioning body, so that those two are part of the same coin, two sides of the same coin. And so of course we'd have to make sure that the sanctioning body was following their own rules, which may be a sporadic audit or something, and just verifying their rules, making sure that they're following their own rules, but and not necessarily certify the sanctioning body, but if we saw that they're out of violation of some of their own rules, then bring that to the commission for the commission to just have that discussion of should they still be an approved body, that kind of a thing. But that would happen with the complete deregulation departmental bill that we were pushing prior to this season. Now the legislative season isn't over. Just departmental bill isn't pushing the initiative. But the legislators, they could still consider that. There's nothing keeping them from considering that. If a constituent was concerned about that and brought that to their representative, then the representative could take that up. Absolutely. Any other questions on that?
Mr. Chairman, I would move that we accept the amateur event permit as presented. That's a motion.
Second.
All in favor?
Aye. Aye.
Gentlemen, unless you have any other new business, we can adjourn. And Chairman, if you'd like to, if you, of course, the prerogative is yours. If you'd like to discuss anything else, we're at your disposal. But unless you had something else, if you want to make a motion in that regard, then we can.
I have a 15-second question/comment.
Sure.
I'm sure it's probably somewhere on the website, the state's website, but would it be too much trouble to get a periodic update on fights that are coming down the pike to the commission members?
That is available on the website, so you're right in that regard. I can send you
Or
a
maybe you
link.
can just send us a link, and
I'll
then I
send you
can
a link.
save the,
Yep.
Perfect.
That would be fine.
It is on there. I look at it often, but it's buried. It's hard to navigate, and it's hard too to kind of understand exactly where those bouts and places, and so I don't know how you fix that.
If I spent too much time on it, I'm just thinking that
We can put
the state.
What was real helpful in the past is our previous executive director, amongst a lot of things, he did great. And it's just a shame we couldn't financially continue that relationship. But he would each month just send us a little calendar. Here's what's going on. Such and such date Knoxville, such and such date Memphis. And that's what you're speaking to. And I don't know if the department has time to do that, but that wouldn't be a high effort by anybody.
We actually have done that since then. We have a calendar where folks can put in a tentative date, and then they can, so it's not just hard dates that they've already got a permit, but they have a place where they can, where promoters can say, yeah, tentatively, I think I might do a fight there. But then they also have folks that have applied and have been approved for permits, and we have a separate link for that. I'll give you both, because that's basically the former executive director for what you're referring to. That's what he did in paper form, but of course you had to wait on him to send that to you as well, whereas now you can check that anytime you want as the updates come in. So I'll send you both those links. Sure.
I don't think we've had a 3-hour plus meeting in years, so thank you.
You guys talk too much.
Do I hear a motion to adjourn?
So move.
Second?
Second.
All in favor?
Oh my goodness, alive. That camera off now.